Abuseni como chani so Allege protects abri. Unia Law.Martin Kpebu na mero kase watimi alenke eye ken ofori Atta. Two eye Sedinam temokru eye inissue no. Na unia watimi indict papa no based on eye bas via ma mene e procure ya allegedly na inflated prices allegedly na Mr. say nyambungura ayi insimnim abra Law.Martin Kpebu ademre na obi nchiremu efasa nsemusim Allege politics up.
It depends on your philosophy as a lawyer or as a judge. You see, so there is some room for discretion. What he's saying, yes, Section 31 of the Courts Act and Section 406 of Act 30 are true, right? But in terms of deciding that this is a good case to apply them would then depend on the outlook, the philosophy of the judge. So what I'm saying, that's what we mean by two lawyers never agreeing on one point. Yes, this one has a different view, the other one has another. So he has quoted his, that's Kpebu, meaning that that's how he would have dealt with it, right? But he's not the judge. That's the unfortunate situation. So in the democracy, he's allowed to hold his opinion. Yes, because you see, that's the way it is. So I cannot totally say that he's so wrong. No, he's coming from a different perspective, right? Which is in the law, right? And but that's not the end. There are other people who see it differently. Now let's go straight into the case. I'm most interested in the 350 cars. And I said the moment I saw that
procured for GPRTU.
Yes, 350 cars. And
the charge was that they were inflated.
Perfect. So let's come this way. When the MPP administration took over, Atta renegotiated the contract. Atta renegotiated the contract. If you knew that the contract is so terrible, it's so bad, the overinflation, etc., deal with it legally to abrogate. Right? Because you can show fraud, etc. Deal with it. But you chose to renegotiate. So after renegotiating, how do you come back and still saddle Sedinam with the consequences of that contract? It was renegotiated. That's what Atta did. And the Egyptian company, so I understand, they were represented by... they were represented by, what do you call it, the W0rsєn company, right? Yeah. So once it's been renegotiated, it's difficult. I don't understand why you still want to hold Sedinam responsible. If they were charging Atta for it, then it would have been a different matter. But once you renegotiate, to renegotiate a contract, you've met a contract, it has certain prices. Then you go into it and say, no, this is too high, this. You renegotiate, then and sign. So that's a fresh contract. Then you come back and say you hold Sedinam again. I cannot understand that. Don't touch it. So that part, I disagree with Kpebu. I don't know how he's going to apply sections 31 and then section 406. No.
Renegotiation, then payment was made?
Yes, by Atta. It's not even in 2017, no. In 2018, I lie. In 2018, more than 1 year after coming into office. So why do you go and saddle it? Remember, Sedinam didn't pay 1 cedi on it. So me, the day I heard that part, I was like, Atta again. Atta again. Can you imagine? How do you renegotiate a contract and then go back and say you are holding the previous person responsible? Then you would find the other parts where Sticker himself came to give evidence. He's PW1.
You mean Dr. Sedinam?
Yes.
The Shares MP?
Yes. At that time, he was head of mass law.
Yes.
Where he said, part of the charges were no longer relevant, etc. It's Sticker's own evidence. You see? So me, because the Allege is gone on appeal, as I say, you know the way I do my things, the part I'm very confident of, I'll speak clearly. The one I'm not confident, then I'll leave it for the Supreme Court to decide. So as for the basis side, to the extent that it was renegotiated and so paid under MPP, I don't see how we can hold Sedinam. And please, let's repeat, for the avoidance of doubt, the charges are what? 78. So when I talk about these ones, these ones don't cover all. And the part where sticker that Sedinam came to admit that the payments were made, the money was duly used, it means that all those charges, I expect that the Attorney General will lose that side. But I'm not talking about all the 78. So I should not be understood to have covered all the 78. No, I'll speak confidently only about the ones that I fully understand. The other ones, it's good. ADG has better understanding of the case. So that one, I'll yield to him.
Yes, but then some of the charges were found defective. The courts struck out and dealt with those charges that could stand. And it is not about whether or not...
That's the grounds of appeal.
Yes.
It happens, infelicity of the lawyer. So certain grounds, there are rules on how to frame grounds of appeal. So they found about 8 of the grounds or so not well laid out. So those were struck out. But there were enough grounds to be able to deal with the whole case. There's one when that can cover everything. When you say the judgment is against the weight of the record, we are not going too technical. Let me make it simple. It just means that there is an omnibus ground that you can use and then you'll be home and dry. So there were sufficient grounds to deal with it. So that's a minor point.
Well, but it is a matter of the state not being able to prove its case beyond reasonable doubt. That's the threshold.
Yes.
That the Court of Appeal was looking for.
Yes.
In a criminal matter like this.
Yes.
But the Attorney General says he is convinced that the charges have merit.
Oh, that's the nature of the law. So the Attorney General takes one position. The accused and his lawyers will also take a different position. And at the end of the day, the judge decides. So let's be very clear. It's not every time that we agree with the judges. No, they may be right. It's also possible that they will be wrong. But they have the mandate to decide. So the Supreme Court, you read something, they'll tell you that, look, yes, that's the way we have seen it, and that's how we decided. You see, and the Supreme Court is the final court. So, you ask lawyers, there are a lot of cases you go, amongst us at the bar. You see, that as a lawyer, you disagree with them to the end, when you are at the losing end, thinking that your case is right. But that's the nature of law, that one side wins generally, the other side loses. It's more or less a zero-sum game, right? So that's why I said, for me, I don't want to spill too much energy on those ones that you don't have the final say. So the fact that the Court of Appeal is saying these ones, they don't meet the threshold, etc. As I've told you, there are some of them I think there is merit. Other ones is a court that will decide. We do not necessarily have to always agree. Look, there's one of the facts that the time they were playing out these facts, it never came out. You see, Sedinam was said to have met Obatampa and taking cash.
So 500,000 at some filling station in Bachona.
Excellent. Then it turns out that after that date of the cash, there are letters that she's written demanding the money. But throughout...
They're demanding some interest payment.
No, the money as well.
Yes.
Eddie also. Yes. Demanding the actual money. Yes, I saw that part of the judgment. So I said, we're just told that she received cash. So how come that there are letters demanding the money after that date? So it creates a doubt. If they had gone to prove that, no, this letter is fake. You see, you are said to have collected money on this date, X. So today, 1st August. Then it turns out that you have, let's just use the same Sedinam. So let's say Sedinam is said to have collected the money on 1st August, the cash. So that's in the area of stealing. But it turns out that 8th August, 20th August, etc., she's made demands for that same cash, demand notice. So then it means that, which one is which? So in that case, it means that the state has a burden to be able to prove that, no, these letters are fake. These letters are fake. Because otherwise, it means that you believe in Obatampa over Sedinam. Meanwhile, there are documents to show that, no, she also has a defense to it. So that part, I was like, so how come that, of course, that's how cases are reported. Often, we like to give a dog a bad name and hang it quickly. Throughout the discussion on the case, those letters were not mentioned. It was yesterday as I read through in preparation, and I said, oh, there's this one. So that one, there's a doubt in that area. So there are some of the charges that obviously you could see that the state couldn't meet the burden of proof. But I would not stick my neck and say for everything there was no. There are some, I think, that let the Supreme Court decide. So I'm not expecting that in the Supreme Court, the accused should win everything.
Oh,
no.
the 78?
Yes. Some of them, it's possible that there could be something other than a success for the accused. But others were very, very clear that this kind of charges should not have gone there. As I said, the part about the buses. And when you mention those vehicles, the 350 vehicles, they had a value of what? 61.7 million. 61.7 million Ghana. That's what was paid, the renegotiated price. So that's a huge side of a huge part of the case itself, a very huge part. So that part, I support Sedinam that no, she should not be answering for that. Once Ofori-Atta renegotiated with the DA2, etc., then if they want, they should have charged them together, if they think so. Also meaning that in other ways, nobody should be held for that.
Right.
The buses side. And then the part sticker came to admit that, look, the money was duly used for those services.
But on the 500,000, the only evidence, at least based on what the judgment says, the only evidence tying her to it was a letter she supposedly signed acknowledging receipt. But in the police statement, Sedinam had said she cannot vouch that the letter was signed by her, even though the signature looks like hers. So instead of asking whether the prosecution had proved she wrote that letter, what the trial judge asked whether she had disproved it, some have described that as a bit questionable.
Excellent.
And that's what the Court of Appeal found, that the presumption of innocence doesn't ask an accused to clear her name.
Thank you.
It asks the state to establish guilt. The letter was never given properly authenticated as a Maslog document. So that's on the basis of which the charge fell.
Yeah.
It didn't go through. But the MPP says, and I'm saying, I'll come to you on this, that this is a travesty of justice. This decision by the Court of Appeal to acquit and discharge Sedinam Tamaklo. Why?
Alfred, good morning again to my good brothers here and your viewers. I would have loved to listen to Allege before coming in. And then also, before I make any comment, if you will indulge me, that would be nice. But if not, I can proceed. Would you grant me?
We'll have two sessions on this.
All right. So, you see,
the next 6 minutes.
Yeah, I want us to depersonalize the matter and look at the issues as they are. That our commitment is to fight corruption without respect to the individuals involved in the matter. So the discussion should be dispassionate, focused on the grand effort to fight corruption. And around this table, all of us are interested in curtailing corruption because of the demonstrable effect it has on our forward march as a country. So it's a matter that there is no disagreement. Now, when there are issues of corruption, our default position as a people should be that we should set examples that would deter people in the future to want to lend themselves to corruption. So I asked the question that in this particular case, where we are nitpicking and looking for grounds to acquit an individual in that exercise where we are collectively in agreement that we want to deter people from abusing their offices, leveraging their offices for personal end, we are looking for nano-micro basis to acquit an individual. It makes nonsense of the whole effort of fighting corruption. That, for me, is the conversation. Not about legal thing, legal that, legal this. Because as my brother Kpebu has demonstrated, in the law, you can always find basis to justify why you won't punish somebody. You can only find it, always find it. And in this occasion, it's been found. Notwithstanding the validation of the judgment by even the US authorities, which was the basis for the extradition. Notwithstanding that validation, because they looked at the case themselves and established and were satisfied that, yes, there's a case here, so therefore the person should go and answer for it. The Attorney General of this republic, while I see that to be a ruse, his points suggest that, yes, there's a basis for why that ruling or that judgment by the High Court should not be overturned.
He says he sees some merit in some of the charges. You said that's a ruse.
I don't know, I'm saying that.
He's filed a notice of appeal, stay of execution.
I don't disagree. I don't disagree, but I'm just saying that it's a face-saving exercise.
The stay of execution.
Oh, yes, of course. Because if you are a government that campaigned that you are coming to fight corruption, and you have come into office, your first order of business was to file nolle prosequi and clear your people. On another occasion, one of your persons who have been jailed or convicted of a crime, you have found grounds to absolve the person from accountability. And you think that Ghanaians outraged about that? You think that the government would just sit back and say, well, I do what I do? This thing is political. We can see it. This government is on a path to set two standards in this country, whereupon some people are more equal and others are not. Some are above the law and others are not above the law. That's the appearance of what we're seeing. It may not be calculated. You can argue, and Edwige will certainly argue, that it is not contrived to set two standards in this country where some are above and some are not.
So the trial judge fundamentally misdirected herself on the burden of proof. They say that the trial judge in the first instance in 2024, who ruled that Sedinam is guilty of those charges that led to the 10-year jail term, fundamentally misdirected herself on the burden of proof, that the prosecution, not the accused, bore the burden of proof, of proving every element of the offense beyond reasonable doubt and not said in Atamakula. Also, the trial judge on the matter of the burden of proof says the court held that the High Court wrongly shifted the burden onto the appellant to prove that she acted with authority or complied with due process merely because the charges allege she acted, quote, without authorization or without due process. The presumption of innocence remained intact throughout the trial. The reasoning of the Court of Appeal justices is that the court reaffirmed the golden thread of criminal law that the burden of proof never shifts unless a statute expressly says so. A prosecutor cannot shift that burden simply by drafting charges in negative terms. Also, the prosecution failed to establish the essential ingredients.
We ain't some who team course channel, so I'm not so jam redasane. Say, Obadi India don't be a assume.